Welcome to Brookland Computer Services. My name is Eamonn Fogarty. I'm the MD at Brookland, and I'm here today to talk to you about GDPR and look at it how it can affect your whole business. Not look at it isolated in a particular area, but look at the whole thing. The future ain't what it used to be. The future in business is constantly changing. Unless we change with it, we will not survive. And regulation is part of that business, whether we like it or we don't. We have employment legislation over the years, we have health and safety legislation. If you're in financial services, which many of you are, then you've got MiFID just come in, but you've had 20 years of increasing regulation. So the change is something we accept, something we move with, and understanding it gives us an advantage, not a disadvantage. I also like to look at it this way. There are three kinds of companies. Those that make things happen, those that watch things happen, and those that wonder what the hell happened. Now, with GDPR, there are way too many companies still in the last bracket. And we're making this with a week to go to the deadline. And we're getting inquiries from companies today who have still not really started at all and are wondering what they're supposed to do. I've given this presentation in different forms to many organizations over the last 18 months, from extremely large down to small businesses. So bear with me as we go through it. I hope it will enlighten you a little bit about the legislation and make it simple. It doesn't have to be overly complicated, but it is something we need to comply with. So, the GDPR, General Data Protection Regulation. New rules coming in to replace the 1998 Data Protection Act. And it is European-wide and applies to all organizations, no matter where you are in the world. If you deal with data of European citizens, then you should obey GDPR. Will it be affected by Brexit? It will not. We will be obeying this legislation going forward because it's not possible to conduct business in the UK without dealing with Europeans. Let's look at the core areas. General Data Protection Regulations, they come into force on 25th of May 2018, and they look at three core areas: data storage and transfer, how we store and manage data, how we transfer and share it. Data subject rights, and that's the core of it. What are the rights of these data subjects? Well, you as a data subject are inheriting a whole bunch of rights, so we'll talk about those in a moment and you'll understand them a little bit better, but that's the center of this regulation. And then accountability and governance. Who's accountable, not just as an organization, but what individuals within that organization are accountable. Before we move any further, let us take a very, very brief look at data subject. What is a data subject? Who is a data subject? Or what data applies as personal data? Well, as data subjects is anybody within the EU, and as personal data, it is the obvious stuff at first, like your name, your contact details, your telephone number. But it's also things like your IP address, the information on your mobile phone, key facts about you that identify you as an individual in any way, your job title, sporting achievements. And this is critical when you talk to businesses who say, well, we just do B2B. So how does it affect us? Well, every time you record a B2B contact, you tend to record a person's name, email address, telephone number, and that is personal data. GDPR applies equally to all accessible data, whether it's paper-based or it's electronic. Now, electronic is the big focus area, and that's where people will be thinking first, and that's where the ICO is probably most concerned because it's the greatest scope for abusing data. But remember, the regulations apply to both, and particularly in safeguarding and looking after data, you must also have measures in place to mind, monitor, control paper data as well as electronic data. Let's look at 8 rights of the data subject. You watching this, I'm sure you're a data subject. Almost certainly you will be. And these are rights you have. So for this slide, don't think about this as a company. Think about this as you as an individual. You have a right to be informed. When someone collects data from you, they should tell you why they're collecting it, what they're going to do with it, who they're going to share it with, what their lawful basis for collecting it, and that's a phrase we'll come back to later, and how long they're going to keep it. And this is where you will be issued with that information each time someone collects your data, so in future you understand why, what, and where. You have a right of access. So you can contact any organization you think may hold data on you. You don't have to know for certain. And you can ask them what data they hold, and they must tell you. They cannot charge you, and they usually have 28 days to do so. There are some exceptions where they can take longer, but in general it's 28 days. You have a right to rectification. If somebody's holding data on you that's incorrect, you can inform them it's incorrect and they have a duty to correct it. Now they can ask for reasonable proof that it is incorrect and for your identity, but they have a legal obligation to correct it. They cannot just ignore you. You have a right of erasure. Now this is a more complex one. Yes, you have a right to have your data removed if the only reason somebody's holding it is your consent. But there are a lot of other lawful bases. I know this is a phrase that keeps cropping up and will be explained a little bit later. And underneath this, you have certain rights, but so does the organization. So I usually say at this stage, writing to HMRC and telling them you no longer exist is not going to work. You have a right to restrict. So fine, if you can't insist somebody deletes your data, you can insist that they only use your data for the purposes they've got. Lawful basis or good reason is another way to express that. And you can say that's the only purpose you can use my data for. You have a right to portability. Organizations must cooperate in letting you move data from one place to another. The best example of this has been, before these regulations even come in, the banks over the last few years have changed the way they operate. If you now move account from one place to another, they cooperate, they help you move it, they transfer your direct debits, they transfer your standing orders. Even deposits that go into the old account later on, they'll automatically forward to the new account. The two banks will cooperate. And this is the spirit that they want to see with other organizations. As we as individuals move around and move our data, organizations should cooperate reasonably with us to make that easy. You have a right to object. Every organization has got to have a process in place to deal with objections or complaints about how they handle data. And again, they're obliged to deal with them and are obliged to respond. And you have rights about profiling. Now this is new and quite powerful. If people are making decisions about you or profiling you through their data, you can ask how they're doing that, what data they're using, what logic they're using. The best example I make of this is you go to apply for credit or a loan. And you sit in front of somebody, you give them all the information, and they come back with the computer says no. And in the past, that was it. That was the end of the conversation. The computer says no. Well, that's not going to be the way going forward. You can say, I want to know how the computer reached its decision, what logic it used, and they're obliged to share that with you. So you can understand how the decision was reached. Now, it doesn't mean that you're entitled to credit that you shouldn't have. But it does mean that if any of the data or process used to make that decision was flawed, you have that opportunity to have that corrected. And that again empowers the citizen with their own data. Let's look at two phrases that are going to keep coming up: controllers and processors. In this legislation, there are data controllers and there are data processors defined. Data controllers, in general, the simple way to think about this is if you take data and you decide what to do with it, you're probably a data controller. If you're given data by a data controller and you're instructed to carry out certain actions with that, you're probably a data processor. But it doesn't actually matter all that much which you are, because the legislation has been very, very clever about tying these together in what can be referred to as a double bind. The controller has an obligation to make sure that his data processor is acting lawfully. And the data processor has a duty to ensure that he's receiving lawful instruction, and by definition therefore that the controller is acting lawfully. And neither of them can afford to ignore this, because processing data that your controller is not acting lawfully could bring liability onto you as a processor, and most definitely as a controller, passing data to a processor who's not acting lawfully is very likely to bring liability back to you as a controller. So this is going to be exceptionally powerful in getting people to act correctly and using commercial pressure to make sure the legislation is enacted and enforced correctly, because businesses will not want to deal with others who do not act within the law, because the liability could come back on them. Now, I don't think this will change overnight on the 25th, because if your key suppliers are saying, well, they're getting ready to deal with it, they're preparing, they're nearly there, then you'll stick with them. They're key suppliers. You'll accept some risk. But as time goes on, if they don't clean up their act and can't assure you that they are completely compliant, then you'll have their competitors who will be. And you will look at your risk and you'll go, why do I want to deal with that supplier and carry some risk? And it is considerable risk. It's not just the fines, which are in effect unlimited for most businesses, since the first cap level that comes in is 20 million. That's for a data breach, 10 million for just failing to comply with the legislation. But it is also the risk of being sued. Because if you abuse somebody's data, they have a right of redress. So it is a risk on two sides that there's no reason to take it, and you'll just decide to deal with processors or controllers who are acting lawfully. Let's look at 7 key principles. Now we're back with our business hat on, thinking about this as a business. Lawfulness. You should only collect data that you have a lawful, fair, and transparent way of collecting. You need a lawful basis, you need to be fair about what you're collecting, and you need to be transparent with the data subject, what you're collecting, why you're collecting, and what you're going to do with it. You should only use the data for the purposes you collected it. Now that might seem obvious, but in law it does need to be stated, because just because you collected it correctly doesn't mean that you will always process it correctly. Well, it's telling you here that you must. Minimalization. You must only collect the amount of data you need to carry out the task, not collecting extra data because it might be useful. Maybe you'll use it in the future. No, your duty is to only collect the amount of data you require. You have a duty to keep the data accurate. Now, this will range on what you're doing. It's not necessarily always your job to be the private detective and go find out if something's changed. But if you could reasonably know that the data is changing, then you have a duty to update it, or if you're informed it's changed, you have a duty to update it. You should define a retention period for all data. How long should you keep the data? Yeah, for example, at the moment, if I ordered goods online and they were delivered to me 5 years ago, there's a very good chance that company still has my data sitting on their database. Why? There's no reason for them to be holding it. Now, in other cases, there are reasons to hold records for years and years. So don't think that data retention policies have to mean that you cannot hold data. It just means you can only hold it for as long as you have good reason or lawful basis for holding it. Integrity. You have a duty to keep data safe and not allow it to be manipulated or altered in an unreasonable way for the data subject. And you have accountability. You as an organization are responsible and individuals within your organization are responsible. And the ICO is looking to organizations to take this responsibility seriously and show respect for subject data. Right, I've kept referring to lawful basis. So let's talk about it for a second. Lawful basis are, in other words, your legal reason, your lawful reason, your reasonable reason. Use any of these words. Why are you holding data? The first one I've put at the top of the list is consent, because everybody else does, and everywhere you read about GDPR, people spend forever talking about consent. Now, I will have a slide in a moment that does dedicate the whole slide to consent. But for a second, let's just skip that, because that's not the best basis. The best basis for most organizations are some of the ones listed here below. In the performance of a contract to which the data subject is a party. If you have a contract, you're entitled to collect, process, hold the data that's reasonably necessary to fulfill that contract. So in many B2B services, for example, that is your main reason. You're fulfilling a contract, and in this case, remember, it's nice to have a written contract and terms and conditions signed up. But once there is a commercial transaction taking place, there's an expectation of some kind of delivery by the data subject, and there's a duty for some kind of fulfillment by the controller. That forms a contract. And on that basis, you can collect the data that is necessary and reasonable, and you can hold it for as long as is reasonable to fulfill that contract. Compliance with a legal obligation is another one. I work with many financial services clients. And in that sector, there is very strong legal obligation to how long you hold data. So if you're compelled by the FCA Or if you're a law firm by the Law Society, or your accountants by your own governing bodies to hold data, then that is a lawful reason for holding data. Now, it doesn't mean you can use it for other purposes, but you can use it for the purposes that the professional body or the law requires you to use it for. There is also the protection of the vital interest of the data subject. Many of us hold data for these reasons. Your financial records are often held for these reasons. Accounting records are held for these reasons. But so is information about food that goes through the food chain, goods that might be dangerous and need recalls, etc. If you are holding data for the sake of the data subject, to give them protection, then you can continue to do so. But we keep coming back. You can hold it, but use it only for those purposes. The next two I find are less applicable perhaps to many of the clients I deal with. I think they apply a bit more to public service bodies, but your tasks carried out in the public interest and exercise of official authority. The last one is a very interesting one, for the purpose of legitimate interest pursued by the controller. This is the most complex in my view, and it is also going to be the most abused in my view. And I expect there'll be further guidance out of the ICO about what we can, cannot, should and should not do under legitimate interest clauses. For now, I'm not going to harp on it because it's a subject in its own right, and I'll probably do a separate presentation on that. I certainly have some papers on it I'm very, very happy to share, and will be on our website. But suffice to say at this point, if you need to do something that you think is reasonable in business, often around marketing, I'll be honest in this case, and it seems though you cannot do it under any of the other bases, and we've yet to come back to consent, under any of the other bases, then consider legitimate interest and take some advice at that point about legitimate interest. Right, we said we'd come back to consent. Let's look at consent in its own right. Consent is great, it's powerful. You can ask people for permission, and assuming they give you permission, and again, I'm not talking about vulnerable individuals or children in this category, they need a slightly different process. But if they give you permission to do something reasonable and fair, then you can do it. However, they can withdraw it at any point, and you must cease to do it, and you must remove the data. So from a business point of view, it's quite a weak basis. If you do rely on consent, there are some things you must remember. You must be able to demonstrate when and where you got consent. It must be clearly distinguishable when you got consent. So the question you ask cannot be buried in terms and conditions. It must be clear upfront, and it must be very obvious that you're asking for permission. It must not lead the subject to believe that it is a requirement. It must be easily accessible. You are very likely to be asked to reproduce this. So you should keep records that are easily accessible that you can show to the ICO or any other governing body if you're quizzed as to why you're processing data for a particular subject. You must use clear and plain language. I think that's getting fairly obvious in this process. The language must be clear and simple for people to understand. At the time you collect the data, you must inform them of their right to withdraw. And it must be easy for them to withdraw consent. Consent must be freely given. Again, this is slightly complex, but suffice to say at this stage that you cannot unreasonably demand it tied in with something else. So I bought goods. In order to take delivery of those goods, you cannot insist I give you permission to market to me. That would be not freely given. And it must be given by somebody who can reasonably understand the permission they're giving. And this is very significant. If you infringe any of these rights, you lose the consent. Excuse me, you lose the consent. So a very good example of this is you worked very hard to get lots of people onto a mailing list that you could send them a newsletter. And another group company thought, look, I've got a great thing I'd like to share with those people. Can I send it out to your list? You let them send it out to your list. They have infringed because they didn't have consent. And you have infringed because you've shared that list with somebody who didn't have consent. So you lose your permissions. So you cannot now continue to send out your newsletters. Let's look at 14 key areas of action that we would suggest a business should consider to be ready for GDPR. Look at your privacy governance. document a risk assessment and assign privacy roles and responsibilities. What data, how significant is it, who's responsible for it, how are you going to keep it safe. Data inventory, list all personal data held and map key processes and data flows. What data do you hold? How do you share it within your business? How do you share it outside of your business? Privacy policy, document what your privacy policy is. And this should tell anybody whose data you're collecting, and it should be given to people when you collect their data. It should tell them what data you collect, why you collect it, what your lawful basis is, how you process it, who you share it with, and how long you're going to keep it. It's an important document. It sets out your stall on what you're going to do with their data, and they're entitled to know that. Collection and consent policy. Where you collect data, document where you collect it, how you collect it. If consent is required, ensure that you're getting consent in a compliant manner, and draft, update and erasure policies. So people know how they can have their data updated, and staff are trained on this, and how they can request to have their data removed. Training and awareness. All your staff should receive training on GDPR. It is very difficult to have people within your organization who do not handle personal data, and if they handle personal data, they should be trained. Now, the training can be relevant to their role, but it's important that all staff who handle personal data are aware of their obligations and know that they need to show respect to this data and therefore to the data subject. Security and risk assessment. Look at the data you're holding. Is your security appropriate to the risks involved? So this will be very much controlled by the type of data you hold and the way in which you need to share and move around this data. Look at third-party risks. As we talked about earlier, the controller and the processor are bound together, both of them having a responsibility to ensure the other is acting correctly. So wherever you're sharing data, whether others are giving it to you and therefore they're the controller and you're the processor perhaps, or where you're the controller sharing with a processor, ensure that they're acting correctly. Now, the legislation doesn't call for you to put processes in place that are onerous or unreasonable for you as an organization. So I'm not suggesting you go out and you physically audit everybody you deal with. That may be necessary if they're handling high sensitivity data or if you have reason to believe they may not be acting correctly. But in general, we're saying you should send a questionnaire to those you share with and ask them to fill out that questionnaire to assure you that they are acting correctly and that they have the correct policies and processes in place to safeguard the data you're giving them and therefore safeguard the rights of the data subjects involved. Privacy notices. Wherever you collect data, you should have privacy notices available. So this is through your website. This is perhaps associated with email collection. Or if you're out on the street with paper forms, it's having a privacy notice there that you can give people so they understand what you're going to do with their data. Requests and complaints. Have a documented process in place to handle requests for data, requests for changes, or complaints about how you're handling people's data. Privacy by design. This is a phrase that comes up repeatedly within the legislation. And it wants us to think about privacy from the beginning. Whenever you create a process, change a business, start a new product line, you should always have data privacy as one of the first things you look at, not the last. The same way as many industries already look at health and safety. You know, a building site, before it lays a brick, thinks about, has it taken the right steps to provide a safe environment for its employees? Well, before you take anyone's data and process it, you should consider, have you created a safe process for handling people's data? Data breach. You should have process in place for data breach management. Understand what you're going to do if there is a data breach, how you're going to respond to it. This should be documented and it should be available to all key staff, very often outside of your core IT itself. Because if you have a problem, one of the things you may need to do is shut down access to your core IT. In which case, if that's the only place that your plan is, then your staff don't have access to that plan and cannot execute it. Data handling practices. Look at who's got access to data, why they got access. Do paper files go out to the office? If they do you sign them out? Do you sign them back in? Can you track them? Is data on mobile phones? Is data on laptops? And is it necessary where it is? Is there appropriate security? And is it only accessible by the individuals who need access to it? Security and risk mitigation. Look at the security you're taking. Are you doing everything you can to mitigate risks? You can't eliminate them, but you can certainly reduce them to a minimum. And then a gap analysis and action plan. So as you approach the 25th or beyond it, if that's when you get there, then look at what you've got. If you've got weaknesses, areas you're struggling to comply with the legislation, then be honest about that, document it, document what you're doing about it. If there is an investigation, the ICO would far prefer to see that you acknowledged you had a problem and you were addressing it, than you buried it and ignored it, because in that way it'll never be corrected. Right, thank you for that slide. That's a heavy slide with a lot of points on it, but I think it's an important one. As we move, just some quick reminders. Look at the security of processing. Are you processing data securely? Are you using encryption where you should? You don't have to use it everywhere, only where it's required. Are you ensuring confidentiality? Have you got processes to identify breaches? So would you know if a mobile phone was lost? Would you know if a paper file was stolen? Would you know if a filing cabinet was being left unlocked when it shouldn't be? So do the best you can to put into your business processes to identify the risks and particularly identify if data is lost or stolen. Regulatory notification. You have a very important obligation to report to the ICO within 72 hours if you lose personal data. They will not be tolerant with delays on this. There's certain information they'd like, which I've listed on this slide, but that's not what's important. Even if all you can tell them at the time is, look, we think we've had data stolen. It may affect 300 people, data subjects, and it may be names, addresses, telephone numbers, and emails. We think that's the scale, but we don't know. We're investigating. That's fine, but make that report within 72 hours. And be careful on this one as well, because deliberate failure to comply can bring liability on the individuals within the business as well as on the business as a whole. And then data subject notification. If you have a serious data breach that's likely to affect the data subjects, then you may need to report to them so they can take steps to mitigate the risks and so they can understand what's happened to their personal data. All right, a couple of quick reminders here now to lighten it up a little bit and just think about it in this way. Think about, what data do you have? Where do you keep that data? Who's got access to it? Who's responsible for it? When does it come in and out of the organization? When do you collect it? How does it move around? How do you transmit it? What third parties are involved? And do you share only what you need to share with them? If they're a delivery organization, logistics business, you may need to share addresses with them and maybe a telephone number, maybe an email even. But very often I find is people sharing whole delivery dockets with them because it's just the easiest way to ship it to them. Well, that's more data than is necessary. Why are you handling or processing or holding or storing? Use any of those phrases you like. Why have you got personal data? What is your lawful basis? Think about that one carefully, because the ICO are very clear. They do not want you choosing a different lawful base on a different day just because it suits you. When circumstances change for the data subject or the data or your business, then of course you can reevaluate what is your lawful basis for a particular piece of data. But it can't be consent today, contract tomorrow, and best interest of data subject the day after, just because it suits the question you're being asked. So think carefully about it and think that it is being held for a legitimate basis. And think about your IT. Is your IT as secure as you can make it? In this area, I do recommend that you follow some framework. We can talk about those separately, but the best for small businesses is Cyber Essentials. It's a very simple framework. It's a very practical framework that your IT, internal or external, can easily implement. And it's important that you take steps, because through your IT is one of the areas where you are likely to suffer data breaches. What do Brookland do? Well, this is what we do, and this is something that if you want help, we can do it with you, but you can also carry out this internally. We start with a process of preparation and setup, understand your business, educate your people. So our first step really is to go in and deliver a presentation, help people understand what the legislation is and how it's going to affect their business. And that in turn helps to get people to comply and work with you, giving people arbitrary rules. They don't like them, they don't follow them. Carry out a gap analysis. Understand where you are in relation to the legislation. When we do this, we look at 140 points. Other organisations may look at slightly more, slightly less, but that's the sort of scale where you should be looking at these points across the business and deciding, do you comply completely, partly, or not at all, and what do you need to do to comply. I will also say we do have an online 50-question online questionnaire that helps you do some of this. So if you're watching this and you know Brookland, which I'm guessing is why you're watching it, then contact any of us. We're happy to give you a link to an online questionnaire. You can run it there. It'll give you back stats and scores on how you're doing. And then when we're working with somebody, we produce a very comprehensive report that tells people the output of the gap analysis, an action plan on what they need to do, and a toolkit to explain how they need to carry out those actions. And that's the key steps in moving people forward. Some people will ask us, can we come, sit with them, help them write the policies and processes? And of course we will. But it's important that we only help you, because these policies and processes have to reflect your business, how you do things, how you treat data. They're not something that should be written at a distance and then parachuted in and said, right, do this. Because one, it won't be implemented, but two, it will not reflect how you truly work. This is, as I said a second ago, on our questionnaires. We break our questionnaires in 140 areas. We look at them in different subject groups, and this is the sort of information we then gather to produce an accurate gap analysis and an action plan. It produces a color-coded, detailed report that's easy for people to follow. Right, that finishes the core GDPR area. I was going to cover for a moment some of the cyber areas as well, because while it's very, very important that GDPR is not seen as an IT subject, it most definitely is not. It's about policy, process, attitude and education across the business. However, IT have a part to play, and sometimes a significant part. So if we run through very, very quickly, we'll talk about some IT security pieces and you can decide whether they apply or not. There are many frameworks out there for GDPR, and you're welcome to follow any of them you wish. I would say that the simplest one for a lot of small businesses is Cyber Essentials. It's a very practical set of criteria that you're expected to meet, but it's very simple. It's things like, do you have a firewall? Have you changed the password from the manufacturer password? Do you update your PCs? Do you only give people access to the data they require? Does everybody have an individual log-on to your IT? You know, these are simple things. Are you patching? Are you managing servers, desktops, mobile phones in the way you should? But it's very important to say this is not just about technology that your IT department can implement. It's also about people and processes. And this is where we find some of the biggest weaknesses today. Hackers are not targeting IT the way they did. They're targeting the individuals. These stats may lie, may be honest. We think they're a fair reflection. We think 80 to 90% of data breaches at the moment are being caused by people. People being conned, people being fooled, phishing attacks, impersonations. Some of it is where your processes let you down, and some of it is where your technology lets you down. But educating your people and supporting them is important. If you look at that slightly further, it breaks down into fraudulent emails, malware, spyware, viruses, and impersonations. And these are key areas that are costing businesses every day. And this is some of the reason. I've seen this in business after business over the years. Passwords written on yellow stickies. No, writing them on pink stickies don't make them any safer. They're still a danger. But this is what goes on. It's in people's top drawer. It's stuck to their monitor. Hey, just pick a password. You think I'm joking? These are used for real. And that's a hacker will run an automated tool that'll run thousands and tens of thousands of common passwords in seconds. So these just don't cut it, and they result in you having a data breach, a serious data breach. Consider using two-factor authentication wherever you're holding sensitive data or high-risk data. I mean, today I wouldn't bank with a bank that didn't have two-factor logon. I wouldn't just accept a username and password as access to my bank account. So why should I accept it for other organizations that are holding sensitive data on me, financial data, medical data? Don't accept it. And as an individual, don't accept it. And as an organization, change it. This is simple technology now to implement. So just do it. Look at web security. Web filtering has often been seen as a way to stop employees wasting time. It's far, far more than that. It protects you from being lured to malicious sites. And that is one of the big sources of attack at the moment. So it's an important tool that helps you protect your people. Rights to install software is taken away so that he cannot install, because most of the time he doesn't need to. Most installation is done by the IT department, therefore restrict the rights to that. And that means that if the individual is conned or lured somewhere, clicks on a link he shouldn't, he won't have the power to install, so the hacker won't inherit that power. Every business should have today anti-phishing, antivirus, anti-malware. So if you haven't got it, then I think we're in the wrong conversation, but just make sure it's up to date and it's on all devices. Consider anti-spam, both training for your staff and technology to try and identify those spam emails. It is difficult because some of them are really well written and it's very hard for technology to identify them. But it is one of the big attack surfaces right now is spamming people. So put something in place appropriate to the type of data you're holding. And consider mobile device management. So many organizations I go in to see have email on their mobile devices but have no security on their mobile devices. There's also a lot of people out there using corporate email on their personal device. And this has been encouraged in many ways in recent years. There is only one solution in my view, and that is wherever the corporate data goes, the corporate security goes. So if you're going to permit people to download email onto their mobile devices, then you should also insist that they have corporate security, mobile device management controlled by the company. Yes, this gives the company the ability to lock them out of their device or wipe their device. So that needs to be explained to them. And some of this software allows you to track the location of the device. That needs to be explained to them. But it's important that you have that control. And in the end, if the employee doesn't want that control put on their phone, then you as a business have to consider, do you need them to have email when they're out and about? And if you do, maybe you have to provide a device that lets them do that. But you are responsible for the corporate data and you cannot let it go onto devices that you've got no control over in any way. Someone leaves your business to still have the data, to get the phone stolen outside the tube station, the thief has got your data. Thank you for your time. Thank you for listening to this, and I hope you found it to be of some benefit. Please take a look at the other clips we're doing, but enjoy your day and hopefully I'll see you again soon.